Welcome back to SCOTUS Oral Arguments and Opinions. In this Reading the Tea Leaves episode, I wanted to compare and contrast the oral argument and the opinion in the May 29th, 2025 case called 7-County Infrastructure Coalition versus Eagle County. Please note that this episode is read by an automated voice. This case involved a fight over building a railroad in Utah to transport oil, and questions of whether federal agencies need to study all the environmental effects that might ripple out from that railroad, including oil drilling in Utah and oil refining in Louisiana and Texas, hundreds of miles away. Check out my opinion summary for additional details on this case. The justices' questioning patterns and concerns during argument directly predicted their ultimate analytical approaches. Justice Kavanaugh's policy-focused majority opinion, emphasizing broad deference to agencies, and Justice Sotomayor's legally precise concurrence, focusing narrowly on statutory authority limitations. The oral argument also revealed the fundamental tension between broad policy-driven judicial restraint and narrow legal analysis that would ultimately require separate opinions despite unanimous agreement on the outcome. For these reasons, this case provides an excellent example of how Supreme Court oral arguments can help predict not just results, but reasoning patterns and judicial philosophies that will govern their written opinions. Let's start with Justice Kavanaugh's majority opinion. What stood out to me about Justice Kavanaugh was how his oral argument questioning evolved into a much broader written analysis, though there were definitely consistent themes running through both. During oral argument in December, Justice Kavanaugh focused heavily on technical questions about judicial deference and restraint. Listen to the kind of thing Justice Kavanaugh was focused on. Can I ask you about the nature of judicial review and the nature of deference? Arbitrary and capricious review, of course, is deferential, but it does have both a procedural and substantive reasonableness component. That's lawyer speak for asking about how much courts should second-guess agency decisions. But Kavanaugh also showed concern about courts taking an overly aggressive role and worried about the over-federalization of state law claims. These themes of judicial restraint and federalism concerns clearly animated Kavanaugh's questions during oral argument. What's fascinating is how Kavanaugh took these core themes of judicial restraint and expanded them dramatically in his written majority opinion. The majority opinion talks about NEPA transforming from a modest procedural requirement into a blunt and haphazard tool used by project opponents to delay infrastructure projects. As Justice Kavanaugh opined, a 1970 legislative acorn has grown over the years into a judicial oak that has hindered infrastructure development under the guise of just a little more process. A course correction of sorts is appropriate to bring judicial review under NEPA back in line with the statutory text and common sense. Congress did not design NEPA for judges to hamstring new infrastructure and construction projects. Kavanaugh's written opinion emphasizes that this judicial overreach affects economic development and job creation, writing that NEPA has led to fewer and more expensive railroads, airports, wind turbines, transmission lines, dams, housing developments, highways, bridges, subways, stadiums, arenas, data centers, and the like, and that also means fewer jobs, as new projects become difficult to finance and build in a timely fashion. The opinion even mentions that environmental groups sometimes use NEPA to fight clean energy projects, noting that certain project opponents have relied on NEPA to fight even clean energy projects, from wind farms to hydroelectric dams, from solar farms to geothermal wells. So, while Kavanaugh's written opinion includes broader and more policy-focused points than his oral argument questions, both his oral argument questions and his opinion merge in the areas of judicial restraint and concern about federal overreach. One way to look at this is that Justice Kavanaugh took his technical questions about deference and built them into a comprehensive critique of how environmental law has been applied by courts and agencies. One more area of emphasis. During oral argument, Justice Kavanaugh described NEPA as a purely procedural statute. Throughout Justice Kavanaugh's opinion, he characterizes NEPA as simply a procedural, not substantive statute. For example, he says, simply stated, NEPA is a procedural cross-check, not a substantive roadblock. The goal of the law is to inform agency decision-making, not to paralyze it. In another location, Justice Kavanaugh states, importantly, however, NEPA is purely procedural. This is another area where Justice Kavanaugh's statements at oral argument foreshadowed his eventual outlook. Now, let's discuss Justice Sotomayor. Justice Sotomayor's approach showed both expansion and contraction between oral argument and her written opinion, but with consistent threads running through both. During oral argument, Sotomayor asked exploratory questions about how different environmental tests would work in practice. But even during those broader questions, Sotomayor kept drilling down to the specific legal authority issues that later became central to her concurrence. For instance, Sotomayor asked the key question that ended up driving her concurrence. Do you think, as a common carrier, that this agency could say, we don't like oil refining, and hence, because it creates pollution, I'm not going to build this railroad? When the respondent's lawyer conceded the agency probably couldn't do this, Sotomayor immediately followed up with the legal precision that marks her judicial approach. Then why is it within their purview to say or determine what the increase of refining will be, and whether it'll be damaging when there's another agency that has the power to control that? That exchange during oral argument became the foundation of Sotomayor's written concurrence, which focuses exclusively on the Surface Transportation Board's limited legal authority under federal transportation law. Sotomayor's concurrence explains that railroads are common carriers required by law to transport whatever cargo companies want to ship, so the board can't legally consider the environmental effects of that cargo when deciding whether to approve the railroad. So while Justice Sotomayor's questioning did range more broadly during oral argument, Justice Sotomayor was already zeroing in on the narrow legal authority question that would dominate the written concurrence. The written opinion represents a deliberate choice to focus on that legal issue while explicitly rejecting the majority's broader policy analysis. As Sotomayor wrote, the majority takes a different path, unnecessarily grounding its analysis largely in matters of policy. What we see with Sotomayor is consistent legal precision, whether in oral argument questions or written analysis, with a preference for resolving cases on the narrowest possible legal grounds rather than broader policy considerations. Here's another pattern that really struck me. Several justices asked active, probing questions during oral argument, but then did not write their own written opinions. Take Justice Barrett. During oral argument, Barrett asked detailed questions about how new congressional requirements for shorter environmental reports would work, whether agencies could consider effects in other states, and how different regulatory schemes interact. Barrett seemed genuinely engaged with the practical challenges of environmental review. But in the final decision, Barrett wrote no separate opinion, simply joining Kavanaugh's majority opinion without additional commentary. Yet, when you look closely at the majority opinion, you can see Barrett's fingerprints. Her oral argument focused on the new congressional requirements limiting environmental reports to 150 pages shows up prominently in Kavanaugh's opinion, which notes that federal law now strictly prohibits an agency's EIS from going on endlessly, and discusses how the Builder Act reinforces NEPA's original intent. Barrett's questions about practical implementation also seem reflected in the majority's emphasis on giving agencies broad latitude to draw a manageable line, and its criticism of courts that micromanage agency choices. So while Barrett stayed silent in writing, Barrett's oral argument concerns about workable standards appear woven throughout the majority opinion, suggesting the kind of behind-the-scenes collaboration that shapes Supreme Court decisions. The same thing happened with Justice Jackson. During oral argument, Jackson was quite skeptical of the petitioner's proposed legal test, questioning whether the approach was unmoored from the purposes of NEPA and challenging the focus on legal responsibility rather than informing agency decision-making. Jackson also wrote no separate opinion, instead joining Sotomayor's concurrence. But when you examine Sotomayor's concurrence closely, you can see Jackson's possible influence. Jackson's oral argument emphasis on NEPA's purpose of informing agency decision-making shows up directly in Sotomayor's written analysis, which states that NEPA's central aim is to improve agency decision-making, and that agencies need only analyze impacts for which their decision would be responsible. Even more tellingly, Jackson's skepticism about approaches that are unmoored from NEPA's purposes appears to have shaped Sotomayor's explicit criticism of the majority for unnecessarily grounding its analysis largely in matters of policy rather than focusing on the legal question of agency authority. So while Jackson wrote no separate opinion, Jackson's concerns about staying true to NEPA's core purpose seem to have helped define the concurrence's approach. Those are some of my takeaways when comparing the oral argument to the opinions. Do you have any others? Feel free to share with me. That's what makes the Supreme Court endlessly fascinating to study. Even when we think we know how the justices will rule based on their questions, the written opinions can still surprise us. And in a system where the reasoning matters just as much as the result, those surprises can have lasting legal and business consequences. Thanks for joining me for this episode.